Well, hello and welcome. You're watching The Watchdog. My name is Liezel Wilson. I'm standing in for my colleague Mkhwebane on the show this evening.
It's frustrating, Kona, to see that I'm now charged for incompetence. I've never brought the country to 8 hours of load shedding.
All suspended public protector advocate Mkhwebane finally gives testimony at impeachment hearing. Day one is wrapped and our legal experts weigh in.
The DPSA therefore takes this opportunity to thank all parties who participated at the facilitation that was led by the Public Service Coordinating Bargaining Council.
I'll focus on the public sector's unions and the Department of Public Service and Administration return to the bargaining table. On that note, the Watchdog starts now. Right, so the parties at the Public Service Coordinating Bargaining Council have concluded a settlement agreement to end the strike and bring back all parties to the negotiating table. This agreement now paves the way for the parties to return to the 2023-2024 wage negotiations.
The DPSA therefore takes this opportunity to thank all parties who participated at the facilitation that was led by the Public Service Coordinating Bargaining Council for their constructive engagement, which culminated in the parties concluding a settlement agreement on the ending of hostilities and an orderly return of public servants to work. The settlement agreement is paving the way for the parties to return to the 2023-2024 wage negotiations. And as part of managing the return of all parties to the negotiating table, a special council has been convened for today, 15 March 2023, to receive the submissions of residual matters emanating from the 2022-2023 wage negotiations. The government further wishes to express its appreciation to those trade unions who remained in the council and continued to negotiate. Government reiterates its commitment to the bargaining process and will work with all relevant partners to ensure that the importance of the system is protected and respected. The government is looking forward to constructive engagements in line with the spirit of the settlement agreement.
Well, joining us now to discuss is now President Mike Shingange. Mike, good evening. Thank you for your time here on The Watchdog. Welcome to the SABC.
Thank you very much. Good evening, Liezel, and to our viewers at home.
Mike, on the back of what's transpired this week, perhaps you can walk us through what's brought the striking unions back to the negotiating table.
Can you please come again?
I was asking what has now brought the striking unions back to the negotiating table?
Oh, yes. Just like has been articulated by the representative of the DPSA, you remember that we were on the street because for a long time now, we have experienced the erosion and the undermining of the collective bargaining in this country, whereby the institution itself, the SABC, but also the papers that the agreements are written on are not respected. It was because of it started in 2020 when government reneged from the 2018 Resolution 1 of 2018, whereby workers went without a salary increase, without a pension increase, without a notch progression, without a bonus increase, followed by the following year where the same thing happened, only they were given gratuity. Then last year, whereas we were still trying to find solution to the thought like what that we had when as workers we rejected the 3%. When we had the conciliation, government went and left us and went to the parliament where we are not represented to pronounce on the conditions of services of our members, thereby undermining and disregarding the institution called Bargaining Council. Our strike was about restoring the principle and the dignity of the collective bargaining. And indeed, what is now has happened is that government is committed to meaningfully engage and respect the collective bargaining. As a result, we are going to be opening up or discussing the gap that exists between us and the 2022-2023 wage negotiations, of course, moving forward to 2023, 2024.
Mike, so with that said, let's look at the scenarios that lie ahead. Where to from here? Is there a possible wage deal on the cards? What can we sort of begin to reimagine at this point?
Yes, there should be a possible wage deal on the card. We, those who were fighting for the respect of the collective bargaining, but also fighting to close the gap that has been opened up since 2020, which is a 3-year gap now in terms of the earning capacity and the buying power of workers and the growth of their notches and the growth of their pensions, had to build a bridge that will take us back to the negotiating table to negotiate 2023 going forward, starting with augmenting, as the settlement agreement says, the issue of the 3% that they unilaterally implemented, because it was important for the workers to push back on unilateralism in this country when we've got a democracy, we've got institutions for social dialogue. So what is going to happen is that the government must present to the council now the settlement agreement, must introduce it and start to put an offer on what is it that they are prepared to add on top of the 3% that was rejected by workers, but they shoved down the throat of the workers. And then unions are going to start to put the percentage which must be put on top of that 3%. And that will constitute the total cost of the next financial year wage agreement that is going to be concluded. So that's what at least that this settlement agreement means. It is in the spirit that it's now in the hands of the government to present that as per the settlement agreement.
Mike, thank you very much for those sentiments. I actually want to bring in, some of the public comments on our social media platforms that, have really come to the fore as the strike continued. And this, in fact, comes from Mickey Maraba. Mickey is asking whether, as we look at a 5-week protest that occurred back in 2017 by Nehao, the leadership and government suspended the strike without its demands being met. And they are now suspending yet again. So Mickey's question is, how long will this continue with resolutions not implemented, whereas the employer imposes a no work, no pay rule? What are the time frames? How would you respond to Mickey's question?
Well, in terms of the time frames, the time frame for this settlement will be at a time when we conclude the 2023-2024. It will have concluded the way forward in as far as the gap we're trying to claw back, the 2022-2023. And we must say, lessons are there to be learned. That is why this time around, this strike and this battle was fought on the different terrains, on a number of other terrains, to a point where a settlement agreement had to be signed, committing the employer, because once you sign a settlement agreement, as we did, it binds between the parties, 2 or more parties that are involved in the dispute. We have unions that and the employer that is involved in the dispute. They have agreed to settle the dispute by signing a settlement agreement. And that settlement agreement takes them into a process which they must find a resolution to that which gave rise to the impasse in the first place. It's a lesson that we take from what she is saying about 2017, which it was a social development strike. The implementation of what was regarded as an agreement that time was hampered by the very same DPSA that today we've signed an agreement with. So we have learned lesson in that. We will endeavor never to repeat that. It's part of the intransigence of our state that it will be in their interest to end the strike, but not commitment in terms of resolving the things that gave rise to the strike in the first place. That is why we had to ensure that we put pen to paper in resolving this strike this time around.
Thank you very much for answering that question, and thank you very much to Mickey for posing that question to you. I think just as we wrap up our conversation at large, ultimately uniting sectors of society against what some call a failing state or against the political dynamics that are unfolding. Perhaps you could just comment on the manner in which this strike was conducted this time round, the impact that it's had on the sectors to date, and perhaps also, going forward, given South Africa's precarious economic situation.
Well, a strike by its nature, firstly, we don't jump into the strike. The intransigence of the state towards workers, or let me put it this way, the violence and that was unleashed on the state started long time ago. The workers have been tolerating this situation. But when we decided to declare a dispute last year, we also did not jump into the strike because we know the strike is a painful process. It affects the workers, but it also affects the society itself. We are not proud of what society had to go through because of our strike. But you must remember that part of our strike was also to highlight the plight of the public in terms of the public service delivery that are supposed to get. Because the workers, the public health care workers, the home affairs workers, the justice workers, the SASA workers are working under unbearable conditions that results in a poor quality service that is delivered to our people because of the shortage of staff. They're underpaid, they're overworked. You must remember that we are talking about these workers who in 2020 and 2021 did not get a salary increase, whereas their leaders in parliament gave themselves a salary increase at a time when they were dying in hospitals, they were dying in the transport intersections, they were taking diseases from hospitals to their families, they watched their colleagues die in hospitals, they could not even bury them, they were trying to defend the nation against the coronavirus. This is the nation that today they are accused of killing. It can't be that these workers who sacrifice their life and that of their family members today turn out to be enemies of the public. It cannot be. We understand and we sympathize with the pain that the public has gone through, but the public must also understand that these are can't be glorified slaves. They are dying too. There are less workers in public health today because their colleagues died during COVID-19. And it is the time when they did not get any incentive, no salary increase, no notch increase, no pension increase, no nothing. It is a time when we had to take the government to court to insist that they must provide protective clothing for both workers and the public institutions. When Department of Health was refusing. It's unfortunate that Department of Health now has appropriated this strike as if it is their strike, whereas it was a strike for public service, not for Department of Health.
Mike, thank you for your time in the SABC. Let's leave the conversation there. Now, President Mike Shingange weighing in on the back of what transpired today. We heard that parties of the Public Service Coordinating Bargaining Council have now concluded a settlement agreement to end the strike, of course, bringing back all the parties to the negotiation table. Again, thank you very much to Mike for his time here on the SABC. So it's time for a quick ad break. The Watchdog continues when we return. All right, so staying with our top story, the Public Sector Association was not a member of the public sector strike, but as part of the bargaining council, joins us for more. This, of course, is on the back of parties at the Public Service Coordinating Bargaining Council having concluded a settlement agreement to end the strike and bring back all parties to the negotiation table. For more, Chairperson Claude Naicker joins me via Zoom. Claude, good evening. Thank you for your time here on the SABC.
Thank you. Thank you. Good evening, and thank you for having me.
All right, so we just spoke to now President Mike Shingange. We want to also get, your sentiments on what's transpired to date. I think my first question is, as we look at, what has transpired to date, perhaps you could speak to why the PSA did not join the NEHAWU's strike from the onset.
Yeah, thank you. Let me put things into perspective. I think there's a lot of confusion out there. You will recall last year, when we started negotiations for last year, the employer offered a 3% salary increase. And what was tantamount or very crucial in the draft offer that they proposed was the cash allowance that public servants are currently receiving will come to an end on 31st of March 2023 this year. Now, that was the bone of contention in the draft proposal, the draft salary offer that was offered last year to public service. PSA and a few other unions were not happy with the clause that was inserted there. As a result, after fruitless negotiations, we declared a dispute and we embarked on industrial actions. And whilst we were on industrial action, the employer unilaterally implemented the offer. They implemented the 3% offer, and obviously the clause that remained indicated that the cash allowance that public servants are receiving will come to an end on 31st of March 2023. Now, once we embarked on strike action, we decided at that stage that if we do continue with protracted strike action with the threat of no work, no pay, we believe that our members in the coming months will be worse off than what they currently are. I think a reality will strike in when on the 15th of April, a lot of public servants will realize that they will be worse off because the cash allowance will actually stop. So this prompted the PSA to decide that we're going to start negotiations for this financial year, the 2023-24 financial year, as soon as possible. The producer block unions, as well as SATU, have decided to embark on negotiations at the Public Service Coordinating Bargaining Council, minus some of our sister unions like NEHAWU. Negotiations have progressed very well at this stage. Currently, the employers offered a 7% pensionable salary increase. Also, a multi-term agreement is also an offer on the table. We will take the 7% offer to our members and seek a mandate to see whether they are happy. But before we do that, we believe, and we believe in good faith, that the employer will come up with a better offer. So we're going to continue with negotiations and we're going to demand a better offer. Because if you look at the 7% that's currently being offered, if the cash allowance does stop on the 1st of April and a 7% is offered, we believe there will be a very negligible increase in the salaries of public servants. Therefore, we're demanding a better offer than 7% that's currently on the table. We're confident that the employer will come back with a better offer. We're also very confident that we can conclude negotiations before the end of March so that come 15th of April, that members will not be out of pocket.
All right, Mike, thank you for that. Actually bringing me to my next question, which involves viewer participation. Mickey earlier on asked Mike Shingange, perhaps I can also pose this question to you and we can take it further. So Mickey Maraba interacting with us at the Watchdog SABC saying, back in 2017, there was a 5-week protest by NEHAWU. The leadership and government suspended the strike without demands being met, and it seems that they're suspending it yet again. How long will this continue? Resolutions not being implemented, especially where the employer imposes a no work, no pay rule. So in essence, the question is, what are those timeframes also then looking like? How would you respond to Mike's concern?
A very critical question. I think one of the things that we weighed when we decided to cease any future strike action was the current economic situation. Yeah. With the threat of no work, no pay, and the number of days that we're going to work in industrial action, I think the loss of pay will far outweigh whatever gains that we actually was going to get if we continued with the negotiations. So in hindsight, we decided that let us try and conclude negotiations for this year as quickly as possible so that members would not be out of pocket. And with the threat of no work, no pay, I think no public servant currently can afford to be without the day's pay. So the only logical solution for the PSA and the few other unions that are currently at the PSABC said, let us try and negotiate. Let us try and negotiate the best deal possible that we can and in the shortest possible time so that members come April could see a tangible increase in the pay packet and they will not be out of pocket. I think what is crucial, and a lot of people don't understand, that once the cash allowance does cease at the end of March, people will be back to square one, as it to say we never started negotiation. So it's important that we try and demand and try and secure a pensionable salary increase that members are happy with and that members can live with going forward, that in the second and third year, if we do negotiate a multi-term agreement, that we can improve on the current offer that's currently on the table.
Claude, just in conclusion, based on the PSCB and having concluded the settlement agreement, given South Africa's precarious economic situation, are you hopeful with regards to the negotiating process as it stands?
I think what we need to understand that the collective bargaining process is such. You can only go into negotiation process and demand a reasonable salary increase. Yeah. And if that doesn't materialize, you cannot continue negotiating forever because members then get frustrated. They don't get a salary increase. Negotiations are protracted. And at the end of the day, you come out with nothing. So the only avenue or the only tool that's available to us is obviously to embark on industrial action. Likewise, the employer on the other side, they can lock employees out, or alternatively, they can unilaterally implement what is on the table. I think the nature of collective bargaining is such, you cannot beg forever. At some stage, you got to declare a dispute and put pressure on the employer. It's part of the labor relations scenario in our country. And strike is something that is synonymous with wage negotiation, because that is the only avenue that we can actually place pressure on the employer to indicate, please give us a better salary increase. Yes, we're cognizant of the financial situation of the country, the economic situation of the country, but a lot has got to do with the way the country has been administered, with the corruption, the maladministration. So why blame public servants for this when a few individuals are looting state coffers and the rest of the public service who are delivering critical services have to suffer as a result of few individuals that are looting the state coffers? I'm hoping and confident that the employer can see all the reasons that we're advancing and improve on the 7% offer so that we can give public servants a better salary increase going into the future.
Claude, thank you for your time here on the SABC. We'll leave the conversation there. Claude Naika, chairperson of PSA, weighing in on the back of what's transpired this week. Again, we know that PSA was not a member of the public sector strike, but has been part of the bargaining council. Let's leave that conversation there. We're going to take a quick ad break. And on the other side of this, suspended public protector Mkhwebane finally takes the stand at her impeachment hearing. Our panel of experts join me when we return.
It's frustrating, Kona, to see that I'm now charged for incompetence. I've never brought the country to 8 hours of load shedding and affect businesses and affect livelihood of people. Some people are dying in hospitals because there are no generators and everything. But I'm sitting here, was trying to change the lives of the people, and I'm being treated like this, maybe because I'm not the right color. I don't know.
Right, welcome back. The Watchdog continues. On the back of that, suspended public protector advocate Mkhwebane has labelled the Section 194 inquiry probing her fitness to hold office as unfair. She has also taken issue with the testimonies of some of the witnesses whom she felt were ganging up against her. Mkhwebane is also feeling hard done by the committee for continuing with its proceedings whilst she was ill. She became emotional in the afternoon session, revealing of at least one incident where she broke down in tears. She fought back tears again as she told the story about her treatment in the committee.
It was very much hurting, I must say, to be treated like that. And worse, it's when you were cross-examining some of the witnesses, and when they are saying bad things about me, and you trying to go to the veracity of the information, and then you come to the issue. But what if she also had fears? What if she also wanted to deliver the best she knows how? And you got a clean audit, and they claim they had clean audit, but they don't want to accept that we had to go through that process. Now, and worse, as I said earlier, you know, there was one stage where I don't know whether you saw me. Fortunately, we were doing a virtual platform. We were on a virtual platform when Utebele was testifying. Well, I cried literally because
I did see that.
Yeah, I felt guilty. I went all out for this country.
Shall I propose a 2 minutes break?
Yes. Thank you. Thank you, Mr. Mwala.
All right. So on the back of that, joining us now is Sinao Makangela, who is an attorney at Makangela Mtungani Inc., as well as Mpumelelo Zigalala from Zigalala Attorneys. Gentlemen, good evening to the both of you, and thank you for your time here on the Watchdog.
Thank you very much for hosting.
Thank you for having me as well.
All right, Mkhwebane, let me start with you. Lots of theatrics coming through today, perhaps on the back of the Public Protector finally taking the stand. It was a suspended Public Protector Rather's first day giving testimony at the impeachment hearing. What do you make of today's events? Mkhwebane, let me start with you, and then we'll go to Snow after.
I think she was painting a picture of saying, look, I'm not a superhuman public protector. Yes, I'm susceptible to mistakes. It doesn't mean that if there's a court order which has been given against me, I'm incompetent. And I've done a lot of good work, including a clean audit that has been able to be obtained within my tenure. So you can't really say that I'm incompetent to that particular extent. And in instances in which I made mistakes or have been found wanting by the court, it is something which is in the ordinary course and scope of the work that has been done. I think maybe in the closing arguments, you might hear submissions similar to also saying even judges, their appeals or their cases are appealed in higher courts. It doesn't mean that the judge that has taken a decision is incompetent. So when you make that particular decision, or as the committee, think about those particular instances. But before you do that, just know that I'm a bit skeptical as to your discretionary powers and the manner in which you're going to judge this matter. I don't really trust what you are doing, but I'm going to move along and comply because I need to make sure that this particular process is done and dusted. I do not want to be accused of Stalin-grant activities or delaying tactics which will cause this particular committee not to finish its work in time.
So now, how would you weigh in on what transpired today in court?
In fact, I agree with my colleague. To take it further, she's demonstrating that the rules of natural justice do not apply in her situations at all times, to the extent that she indicated that she participated in the processes under protest. When she brought an issue where she was ill, but she was forced to come and attend this proceeding. But because, as my colleague indicated, that she never wanted to be accused of employing the Stalingrad approach, she decided to come and participate in this process. Remember, if you talk about fairness, fairness means someone must be fit to stand to come and give evidence, including this kind of an inquiry. Remember, this is the first of its own kind, so you can imagine that it will find its way into the doors of our jurisprudence. So you don't want to mess with this process. It needs to be a process that is above board. But what I could take from her openings is that she's just demonstrating that actually I have been treated as an outcast from day one. There's been a mistrust. I was never liked from the day I assumed the office. As she also gave us the background to the rules that actually they wanted to charge me even before the rules come into existence. So it was just a mess, haphazard kind of a situation that charge this person, whatever the case may be. So what she told the committee is that she has been treated differently from all other South Africans. All the good work that she has done does not matter, but she must be found on the wrong side of the law.
Well, speaking about the mistrust that she echoed upon coming into office, perhaps as we look at what's set to come, how will Mkhwebane's 3-month stint at the SSA, before becoming Public Protector, face scrutiny this week? How will the Official Secrets Act or any other regulations for that matter be used or could be used as a defense? So now, how would you weigh in on that?
In fact, the indication she made was that it was just 3 months for anyone to label me as a spy, because for one to get to know the ins, the pros and cons of that entity called SSA, at least you need to spend some time there. Because even to know who is working there, you have to be there for quite some time, because that's how the entity operates itself. So she's just downplaying it to say, well, that's being ridiculous for anyone to suggest that she was just a spy. Actually, it was one of those made-up stories to taint her bed as this bad person, as this unsuitable candidate to be our public protector, So that's the indication I'm getting. I did not get anything that would get something of substance out of her having served the SSA.
Mkhwebane, do you agree or disagree with Sinawa's sentiments? I'm only asking that because when we look at the bigger picture, I mean, coming out of the evidence that we'll hear this week from the suspended Public Protector, I mean, there's quite a large chunk of missing information when it comes to the overall state capture at large. And how are we going to fill in some of those missing pieces? How would you weigh in on the back of what Sinawa's just echoed?
I fully agree with my Leonard colleague, but then you have to come back and look at the technicalities and say, look at the Public Protectors Act and the regulations that are applicable and say, is there a requirement that says you cannot be a public protector if you worked somewhere else? If you want to assess my incompetence, assess any acts of misconduct, concentrate on those particular acts and nothing else, and make sure that you're able to provide evidence which is going to be able to prove it, and evidence which is going to be able to show that in the manner in which I've acted, in any other reasonable public protector would not have acted in that particular manner. If you can't arrive at that particular conclusion, then you're going to have problems in terms of proving the innocence or the guilt of the current public protector. Another problem that you're going to find is that the presiding officers or the final decision makers in this process, I would say with all due respect, maybe they do not have what it takes to be able to make that particular determination. For example, I can't be taken to assess whether a neurosurgeon is doing their work accurately or not. I'm not a doctor. So if they do something which is incorrect, I'm not going to be able to say, you are not doing something that you ought to have done in the first place. Now, you've taken here a quasi-judicial process and you've attached certain elements which at the end of the day are going to bring in results which are not desired. You have too many individuals being presiding officers, committee members that you can argue with all due respect that are not really qualified to make that particular assessment. And you are saying to them, make a very important job of determining whether the public protector is competent or not. Maybe make a very important job of determining whether acts of misconduct have taken place when you haven't given them the ammunition and the technical know-how of doing that particular assessment. Perfect ground for reviews, and it's certainly something which is not going to end now if indeed it is found that the public protector is incompetent or there is a certain act of misconduct that she has committed.
Speaking of which, the suspended public protector is obviously defending evidence, calling her independence into question, her competence and also understanding of the law. And as we look at what she's going to have to respond to in terms of evidence on reports relating to the SARS rogue unit, you've got the Freedom Farm, you've also got the CIX or the Reserve Bank matter. What is being reflected thus far?
I think on the side of the public protector, or let's say those that are against or that are prosecuting it, they are simply the way that you are so incompetent. Look at what the courts are saying and the type of orders that you've been receiving all along. It's not something that we should be receiving from a public protector of your caliber. But the defense to that is then to say, I'm not a superhuman public protector. I'm allowed to make mistakes as long as they're within the context of my work, which is why she was at pains today in terms of explaining what did she mean when it came to the report she wrote, when it came to the Reserve Bank and the type of powers in which should either reside within the Constitution or in a separate legal legislation. So those are the type of investigations in which, or the type of explanations that she's going to have to do. And you need the right type of caliber of individuals to assess that particular matter, because you then have to say, would a reasonable public protector have taken this decision? You can't have someone who's going to be accurate at all times. You can't have someone who's going to be beyond the reproach when it comes to the fair and accurate judgments. As bizarre as it might sound, you are allowed to make mistakes as long as you make them within the bounds of your profession. As stated earlier, using the example of presiding officers, judges, for example, they do make mistakes. Their judgments are overturned by the SCA and the Concord every other day, but it does not mean that the judge that has taken the initial judgment is incompetent or cannot do their job.
So now, how would you respond to those questions about her having to defend her independence as well as her competence or understanding of the law to date?
In fact, to take it from the last point, if you go to the Supreme Court of Appeal, you'll see its judgments there. They are criticizing the judges of the High Court on a daily basis. A classic case is the judgment of Judge Nicholson from KZN in the President Zuma case, rape case. The SCA, they criticized him, in a very simple language. But that is what it is trying to demonstrate as well, that these mistakes do happen on a daily basis, but you've never heard of those people being called to come and caused to appear in an impeachment proceedings, Remember, she's taking an issue even with the name of the committee, how the whole thing was coined. That is the removal of the Chapter 9 institution. Actually, it's the Committee of the Public Protector. It was initially coined as the removal of the PP. It was changed to be the Chapter 9 institutions. But as the time goes by, when the committee is referred to, it is the committee for the removal of the public protector. It creates an impression that actually there is a decision that has been made. And even if you read those judgments or you consider the judgments that form the foundation of this whole process, I think one judge from the Constitutional Court who was against the majority on a personal cost order was saying, if the courts continue to grant these cost orders, they are restricting the public protector from performing her functions. You are limiting her from performing her duties. Because my colleague puts it nicely to say, for as long as she issues the report, she performs her functions in terms of the Public Protector Act. Obviously, she will commit some of those mistakes. But for one to say that is the foundation of her impeachment, it could be wrong. Think about when her predecessor was called.
Yeah.
And the reference is made into the judgment of Justice Potterelli, a judgment that is law today that has not been appealed against, which is there. A similar remark has been made to her, But those are some of the things that we must prepare ourselves to be confronted with in her testimony.
So speaking about mistakes, the conduct of the public protectors also come to the fore. So now let me start with you, and then I'll bring Mkhwebane back into the conversation. We also say to hear evidence from witnesses who complained about her treatment of officials. That's obviously also going to come to the fore. I wonder how you'd weigh in on that. What precedents is it also setting for other Chapter 9 institutions at this point of the process?
Well, Zikalala puts it, as I say, it's tricky for the members of the committee, actually. Only if the parliament said we want at least people who are legally qualified for this process, maybe you would be getting a different outcome. One of the criticisms that comes there is that people who are testifying against the public protector are disgruntled former employees or employees. Some of them have been subjected to some internal disciplinary hearings. So we know the cautionary rule that it will have to apply in this case, that an aggrieved party who comes and testifies against you, at least that evidence will have to be approached with a very serious caution. I'm not so sure how our honorable members appreciate whether do they appreciate that kind of an approach and that kind of an evidence. That's why his legal team says actually it's more like now the parliament has been turned into a CCMA forum where you would have to deal in detail with the complaints of the employees against the employer, where there are issues, so that you don't bring those issues into this kind of a forum. Well, again, I take it because these are uncharted territories. This is the first of its own kind. They want any evidence that can come and assist whoever wants to get an outcome. But those issues really, if you follow that evidence, will be the issues of the HR. The other one was found to have assaulted someone. The other one committed business gross misconduct at work and then was charged. And the other one resigned before the proceedings, disciplinary processes. But all of a sudden, that person comes in to testify against the very same person who was initiating those proceedings. So remember the process, as we say, you want this process to be above board, because this is the same format that will be used to remove the IEC, to remove the Auditor General. So you want a process that is clean, you want a process that is not questionable, you want a process that is above board.
Thank you very much for those sentiments. And Mpumelelo, I actually want to also then hear your sentiments, with regards to the conduct of the public protector. I'm only asking this because I also want to look at, what the suspended public protector, Mkhwebane's term, has revealed about the constitution at large, the judiciary processes, court judgments, truth, amongst many other issues that seem to have been have a spotlight shone on them at this point, again, as we equate it to some of the other Chapter 9 institutions going forward.
The most important question would be, or the answer would be, what is the perfect public protector? When you say that the public protector has acted beyond approach, there's no certain instances of misconduct that have taken place. How do you determine all those particular facts? And in instances in which you are now second-guessing matters that have been adjudicated and done and dusted, you are bringing them back to the fore again, for example, the employment issues. you are basically saying to the people that were disgruntled with the parties that were there in those particular processes, come and have a second bite at the apple or at the cherry, and maybe the conclusion would be different. It's an incorrect assessment of the misconduct of a public protector. Now, you must set that against a certain number of rules that are there. Labor law is very easy, and it states a rule must be there, it must be known by all before it is broken. So you can't create a rule as you go along and say whatever has taken place must be construed as a misconduct. And in that basis, that is what the public protector is going to be removed upon. The same applies to incompetent. How do you then determine whether someone is competent or not? Did you give them set targets of saying that this are the things in which you must be able to achieve? If you haven't done that at the start, you are going to have a problem if you now try and prosecute them on this basis. Now, this committee has missed a very important opportunity of writing a very good precedent of saying, this is the assessment that you are going to use when determining whether the public protector has done good or whether the public protector has done bad. The rules in which they are using, the type of or elements of biasness that are there, in the manner in which these particular proceedings have been conducted, the type of research and professional or even technical know-how that has gone into this particular committee is going to bring the whole process at the end of the day to something that you can't really use at a later stage. And the only thing in which you're going to use it for is to say, this is how you do not conduct this particular inquiry, because there are no set rules that have been there to determine what is best, what is good, and what is the test that you are using, or the memo. And then you simply say, let us take the facts, apply to the memo the type of rules that are there, and then you can be able to determine whether the public protector has done good or bad. In this particular manner that you are using, it's almost as if we're using a pay-as-you-go type of legal system.
Yeah.
We're creating the rules as we go along.
No, absolutely, which also brings me to the question about the costs incurred to date and perhaps how this is going to be used to advance or assist other Chapter 9 institutions, but also, after this, after Mkhwebane's evidence, the committee is expected to release a report with the recommendations by the end of April. Do you think they're going to meet these timelines? How would you weigh in on that in conclusion before I bring Sinawa in?
Well, they can try and comply with the timelines, but what is more important rather than the period is the content of the report.
Yeah.
Is it what it's supposed to be, and is it going to provide the type of answer that you are looking for? But for now, it will be a report that contains ripe and very important grounds for review proceedings if they find against a public protector.
So now your closing remarks. We're just looking at, after all of this, how this is going to be applied to other Chapter 9 institutions, the costs that have been incurred to date, and, whether we meet that deadline come the end of April by the committee. How would you weigh in that in conclusion?
Well, I think as a starting, in fact, just to take from the last point, we should be having the framework. We all should be knowing what is it that she's expected to meet in Parliament. There should be a framework that she must meet point 1. If she fails, point 2, point 3. At least everyone as well watching the proceedings live. But we now do not know what is it that she must meet. But she's there to be assessed whether she's fit or she must be a candidate to be impeached or not. So the report will be a surprise, actually. As my colleague says, there are many grounds to take it on review. So it's another expense that will be incurred by the very same Parliament. On litigation, starting from the High Court, SA, up to the Con Court. So the road is still very long. It's not going to be short. The issue of the timelines, the complaint she's making as well today is that she's given about a week, when in fact the witnesses that have testified against her have been given some months. She must come and meet a case that has been presented by witnesses for some months in a week's time. That's why I was saying the rules of natural justice are telling you that you must meet an evidence of 6 months in a week's time. I mean, how reasonable is that? At least Parliament, as we say, they are dealing with this candidate now, but they'll be creating a very good framework so that all the Chapter 9 leaders understand that they are expected to perform their work within this particular framework. If they don't do that, they'll be called into question.
Well, let's leave that conversation there. We've run out of time. Thank you to the both of you for joining us here on the Watchdog. Again, lots of questions. that await answers. We'll continue to monitor and see what transpires from here on too. Against now Makangela, attorney at Makangela Mtungani, as well Inc., as well as Mpumelelo Zikalala from Zikalala Attorneys, weighing in on the back of what's transpired. We saw suspended public protector advocate Busisi Mkhwebane taking the stand today. Perhaps before we go, we're going to leave you with some highlights from the suspended public protector advocate Busisi Mkhwebane's first day testifying at her impeachment inquiry. My colleague Bulelani Phillips compiled this report.
Mkhwebane was on the stand for the first day. Her counsel immediately protested that they have been given too little time to respond to the 18 witnesses who have been testifying for months.
The period, that has been allocated for this testimony is too short. We know the issues, you've articulated them, some of them in the letters and so on, but we are very much aggrieved about that.
Proceedings then went ahead, with Mkhwebane getting moral support from her husband and two sisters in the background. First up, she laid out her overview of how she would approach her testimony. Citing various high-profile reports from her office, she also addressed the issue of her suspension, arguing that Ramaphosa was retaliating because she was investigating the Phala matter. Mkhwebane was suspended a day before she won a High Court interim interdict preventing her suspension, but this is being appealed in the Constitutional Court and awaiting a judgment.
It was as if the president was not even respecting the courts, preempting the courts after being informed that the judgment is going to be issued the following day.
And she also took aim at the rules for the removal of a head of a Chapter 9 institution, charging that they were created for her and were a rushed cut and paste job.
Those rules were drafted specifically for me, because there's where in the letter where it says for the removal of the public protector. And that's another issue of the removal, because this process shouldn't be for the removal. This process should be for the determination of the fitness.
She concluded that the inquiry was a politically motivated witch hunt against her for probing the powerful.
It has nothing to do with the Constitution of the Republic and the rule of law. So this process is far removed from the Constitution as the South is to the North. It is a politically motivated witch hunt and masquerading as a bona fide inquiry under the auspices of Section 194 of the committee. So it is a racially motivated, because I would say that born out of fear of change, which might actually benefit the poorest and the most marginalized members of the public, who are in the main blacks and at the expense of those who benefit the most from the economic status. That I will say it boldly.
And she went on even deeper, accusing the Council of the advancement of the South African Constitution. She says the plot is also driven by the DA, assisted by the ANC.
Yes, assisted by the ANC, which is driven also by separate motives of retaliation and revenge for having exposed corruption and other wrongdoing on the part of its most powerful leaders. I would say that this investigation against the president, which we'll deal with in details, and the evidence which we honestly received and dealt with and tested it against the existing laws and not any ulterior motive. The issue of the Phala, because that led to my suspension.
The inquiry continues, and Mkhwebane is due to finish her testimony at the end of this month. Ulelani Philip, SABC News, Parliament.
Well, thank you very much for joining us. We'll leave it there for now. From myself, Liezel Wilson, and the rest of the team, until next time, it's goodbye.